Welcome, everybody. Thank you so much for coming out on a gorgeous, gorgeous Friday afternoon at 3:30 when you could be out on the green. We really appreciate you coming and being here. I'm Julie Kalish. I'm Dartmouth class of 91. I teach for the Institute for Writing and Rhetoric, and I teach a writing class about the Supreme Court, which I believe is why I'm here. This is Bruce Duthu.
Well, I'll just introduce myself. I'm Bruce Duthu. You probably saw on the little overhead. Professor in Native American Studies. I'm also a Dartmouth grad, class of 1980. Are we going to do more?
I'm going to do a little, yeah. So our official title is actually very broad. It is the social implications of civil rights decisions or civil rights cases on the Roberts Court. And there have been a lot. It's been a very interesting term this year and continues to be a very interesting term. There have been fairly big news cases this year, the two same-sex marriage cases, obviously, about DOMA and about Prop 8, where the question of is there actually going to be new civil rights precedent that are going to become landmark cases. There have been also a couple of cases challenging past civil rights decisions and questioning the sort of future of them, whether affirmative action is still going to be a viable civil rights tactic, what's going to become of the Voting Rights Act, whether their Section 5 preclearance requirement is going to be struck down or not. But there's also been another case that probably has not gotten as much press and has not made it to the Stephen Colbert show. No, not quite yet. Possibly someday. It's not very funny. It's really not very funny. And we're going to spend most of our time talking about that case. It involves ICWA, the Indian Child Welfare Act, and the adoption of a little girl. The official title of the case is Adoptive Couple versus Baby Girl, but more sort of popularly, it's called the Baby Veronica case, which is likely how you've heard it referred to. So we're going to do this in a kind of conversation format, and I really encourage all of you to sort of get into the spirit of the conversation format. So feel free at any point to be jumping in, contributing, asking questions, making comments, and we hope that you'll sort of embrace this more interactive approach. So I'm going to first start just what's ICWA?
I want to also thank the organizers before we move on. So Xander and the Law Day folks who have Rockefeller and the Dartmouth Lawyers Association who helped make this event possible. So I want to say sincere thanks for that and echo Julie's thanks for you making time for this afternoon. What I want to do is take a few minutes and just tell you a little bit about this case. I'll refer to it as the Baby Veronica case because it gets very awkward to say baby girl versus adoptive parents over and over again. So a little bit of background on this case. It's a very, very complicated case, so I won't bore you with all of the details, but then give you some flavor for the case and what are some of the broader issues that are implicated by this case, putting it in context with the history behind which Congress wrote this law in 1978. You know, why did Congress feel the need to write such a statute called the Indian Child Welfare Act? And then broaden it even beyond that to talk about broader issues of concern when it comes to placement of children by and large, and how does that compare with non-native children? In other words, what's different about the adoption of native children in the United States, and how does this statute make a difference? And I think part of what Julie and I both printed off copies of the oral arguments before the Supreme Court, which were held on April 16th. I don't know if any of you have ever been to an oral argument of the U.S. Supreme Court. It's fascinating theater. If you don't know the cases intimately, you may be utterly confused and perplexed as to where things are coming from. Why did Justice so-and-so come out of nowhere to ask that particular question? So it's a very, very interesting dynamic. Let me start with the statute itself. Congress wrote this law in 1978 in response to a legacy, a fairly tragic legacy, of outplacement of Native children. In many states, for example, the rate at which or by which Native children were removed by state social workers and placed in usually non-Native homes was exponentially higher than any other group in that state. Minnesota, for example, 35 to 40% higher rates of outplacement than any other group in that state. And in other states, maybe not as high. And so it caused a lot of head scratching in Congress. What's going on? Now, tribal leaders knew exactly what was going on. What was going on was the latest phase of a federal policy calculated to essentially terminate the next generation of Native people. They saw it as a form of cultural genocide, the removal of the next generation of Native children. If you read the definition of the conventions against genocide, cultural genocide, one of the components is state action calculated to lead to the removal of children, of a population, of a group or a people. So this is, from the tribe's perspective, this is very, very alarming. And so to stem the tide of this outflow of Native children and placement into non-Native homes, Congress writes this law and essentially adopts a policy that tries to restore as much authority to tribal courts. Under our system of governance, Indian tribes are sovereign nations. They don't have the same kind of sovereignty as the United States or the states, but in large measure, their sovereign power does include the regulation of group membership rights. And so the statute essentially says, for children that are domiciled within the reservation, within Indian country, the tribes have exclusive jurisdiction. And that's an important concept. Exclusive jurisdictions means if you started a proceeding in state court, and even if it advances to the state of a final adoption, that adoption is null and void if the jurisdiction properly belongs to the Indian tribe. That's what the Supreme Court held in its one and only case that addressed an ICWA issue back in the late 1980s, a case called Mississippi Choctaw versus Holyfield. So in the Holyfield case, that's exactly what happened. A couple of twins had been adopted. They were born off the reservation. Mom and dad were from the reservation. But for some reason, we don't know exactly why, they did not want to go through the tribal proceedings, so they left the res, had already arranged with a non-Native couple, the Holyfields, to adopt their kids. The Holyfields paid for the delivery, they paid for the adoption proceedings. It advanced all the way to a final decree. So this family's holding a piece of paper saying that these twins are ours. And the tribe learned about this adoption, and they said, hold on, this is inappropriate. It's illegal under the federal Indian Child Welfare Act. And that case goes up to the U.S. Supreme Court, and the U.S. Supreme Court agreed and said, these children, notwithstanding the acts of the parents, are still considered to be domiciled within the reservation. And the reason is their understanding of domicile. Domicile is a state of mind. It's the place you call home. And since minors can't determine for themselves a place to call home, they'll take the domicile of the parents. And so the parents' domicile was the reservation, and therefore the children's domicile was the reservation. Reading the statute, the court said that means the tribe, the Mississippi Choctaw Tribal Court, had exclusive jurisdiction. And by now these kids are 3.5 years old. The Holyfields are the only parents they've ever known. And the court acknowledged that in its opinion and said, look, we know there will be some tremendous heartache, but if we had followed the law in the first place, you'd have spared these kids 3.5 years of despair. So the case goes back to the Mississippi Band, the tribal court, and after a hearing and following their procedures, the court ruled that it was in the best interest of those children to remain with the Holyfield. So they did not remove them from their adoptive parents. That was the one and only case up until baby Veronica. Now, the baby Veronica case is different. It doesn't involve a battle over jurisdiction. It involves some fairly technical interpretation of some other terms of the Indian Child Welfare Act. The facts are a bit complicated, but in a very brief summary, you have a Cherokee, a father who's a member of the Cherokee Nation of Oklahoma. The mother is a non-native woman. They were engaged to be married, but she broke it off. She also became pregnant with Veronica. This is in 2009, I think the baby, right? I'm looking at Megan because Megan's writing a thesis on Indian Child Welfare Act. So 2009 is when the baby is born, but during the course of the mom's pregnancy, the engagement is broken off. There were some exchanges, mostly through text messaging, about whether or not he wanted to contribute to the support of the child or end his responsibilities towards the child, and he opted for the latter. In terms of, well, it's your child because he really wanted to get married, and she says the relationship is over. What he didn't know until very late in the game was that her intent was to give up the child for adoption. He didn't learn of that until he was about ready to ship off for Iraq. So he served with papers some 4 months after Veronica is born. He served with papers saying that this is here's an adoption proceeding. And at first he signs it thinking that he's now formally relinquishing his rights to the birth mom. But then at some point he understands that no, that's not what he's doing. She's actually the baby is being given up for adoption. And at that point he's like, no, that's not what I'm agreeing to. I want to raise, if the birth mom doesn't want to raise our daughter, I want to raise our daughter. So that's when he jumps in aggressively to try to thwart the adoption proceedings in the state of South Carolina, which is where the adoptive parents, or the hopeful adoptive parents, were living, the Capobiancos, who has been the subject of a 60 Minutes episode. Some of you may have seen their story as told through 60 Minutes. So that's where the legal proceedings get engaged. The state courts of South Carolina, including the Supreme Court of South Carolina, read the federal statute, and their interpretation of the respective interests here were to place the child with her biological dad. They interpreted the federal law as saying, as the Indian parent, he had a set of rights that the federal law ascribed to him that were different than what South Carolina would have accorded him. And here you get the federalism issue. A different outcome would have happened had you followed state law compared to federal law. So the status, being native and being members of a federally recognized Indian tribe, i.e. a different nation, makes all the difference in the world here. So they said he gets to raise his daughter. So they ordered custody to be transferred to the father. And that's where Veronica has been for the last couple of years. Meanwhile, the Capobiancos have appealed the case, and it is now before the U.S. Supreme Court. They heard arguments on April the 16th. It is anybody's guess as to what the court will do with this case. If you read the arguments, you can see that there's a variety of concerns that many of the justices had. They are, in broad strokes, they are concerns about the proper interpretation of some of the terms of ICWA. They involve a very controversial doctrine that some of the state courts, a few state courts, had developed, known as the existing Indian family exception. And this was the reason it's controversial is that it usually leads to the displacement of an Indian child away from an Indian family or an Indian parent into a non-Indian family. And the reason that some courts have adopted this is they say, well, the overarching principle, objective, of the Indian Child Welfare Act is to preserve Indian families, to prevent them from being broken apart. Well, if there isn't an Indian family already in existence, then the objectives of ICWA or the policy behind ICWA is moot. We don't need to apply ICWA because there's not an Indian family in existence whose interests are being protected. And there was some question about that because the court, some of the justices kept coming back to the point that they were considering, without using this term, but they considered the father to be a marginal Indian person. Chief Justice Roberts, for example, kept hammering away at the idea that this guy was only what was the percentage?
256.
So and another justice said, I mean, the fact that he had ancestors who were on the Cherokee roll at the time of George Washington, what does that matter today, you know? So they kind of put a lot of emphasis on the marginality of his claim to an indigenous ancestry. They did not talk about it in the context of citizenship in a nation. They kept focusing on blood quantum and coming up with what even one of the lawyers called wild hypotheticals. And so they really were pretty wild hypotheticals. I may give you an example down the road. So the existing Indian family exception makes an appearance in this case. And the last category that I want to bring to your attention are some questions directed at some of the lawyers as to the constitutionality itself of this statute. In other words, if you see that what's going on here is a regime, a system, that assigns and accords rights based on one's membership in a specific racial group, and so you have the distribution of legal goods and legal rights on the basis of membership in a group, that is violative of the Constitution. We don't do that. We should not be according and dispensing rights and privileges on the basis of one's membership in a group. Violates our guarantees of equal protection of the laws and due process of the law. So there were a number of questions that looked at, has Congress gone too far in this Indian Child Welfare Act, making all these classifications and setting up a preference schemes where Native families get a preference over non-Native families? Is that right? Is that appropriate to do in this day and age? The last point that I want to make, and it's not related to the arguments, but trying to put in broader context why this case is so important. Those of us who've written about federal Indian law and the Indian Child Welfare Act in particular try to situate it in terms of, well, how do the distribution of rights in this kind of system compare to how we normally see things happening in the state and federal system? And if we look at it through the lens of a political philosophy and our commitment to liberalism, the idea that the individual is the moral bedrock unit of our society. And so government's role is to vindicate, to support the expression of the individual's place in the society, not based on one's membership in a group. So you have here at the broadest level some tension between a focus on individual rights, which is the normative kind of tendency of our constitutional democratic system, and a communitarian focus, group rights, the right of the tribe, that the statute itself very explicitly says the interests of the tribe in its future members, it calls children the most important natural resource. I'm not sure if I like that formulation. Sometimes I look to my children and I say, good morning, natural resource. Just kidding. But Congress looks at, and in the statute, refers to children as the most important resource that tribes have. This is their future. And if they cannot hold on to the members who will constitute the tribe's future, tribal sovereignty is imperiled, right? And so in the statute it says, the tribe's interest in self-governance and in its sovereign authority is on a par to be viewed side by side in parity with the child's best interests. So right there, Congress creates the tension. And judges, state judges especially, who are trained to follow the best interests of the child and to focus on what seems to be best for that individual, are very torn about having to look at what's in the best interest of this group. It is against their natural impulse and against the grain. And that's what makes these cases so hard. That's what makes these cases very difficult for mainstream jurists. Now, it's not to say that if you had a tribal judge sitting there, that they would automatically rule in favor of the Native family. Look at what happened in the Holyfield case. But it was an expression of sovereignty, where that judge basically made a decision. They're the ones applying the best interests of the child. They're the ones deciding this is a situation where we have to let go. Now, they did put a little caveat to say, we urge the family to maintain connections, that these kids know something about their Cherokee ancestry, that they'll know what it means to be Native. And there may be times where that's the best option, depending on the family's resources and so forth. Let me stop there and see if, Julie, you would like to make any linkages to any of that in light of some of the other cases that are before the court.
I actually just wanted to jump off of what you were saying in terms of the tension between the individual right and the community right. Because I think one of the most interesting things as you're listening to or reading the oral argument transcripts is that there are 4 different lawyers arguing in this case because there are so many different interests actually at stake in the case. So the family, the adoptive family, has its own attorney. The child has her own attorney who's representing the interests of the child at stake. The father has his attorney because he has his own set of interests, and the tribe has its attorney who's in the case.
In the U.S., they're kind of...
Yes,
yeah.
The tribe and the U.S. are sort of, they're sharing an attorney. Because the government's interest is in defending the statute.
Exactly.
So there are so many different, and all of these points of view have different competing sort of end results that they're looking for. So in defense of the attorney who's arguing in the best interests of the child doesn't actually have a particular automatic custody result that he's looking for. He's looking for what I want is for the best interests of the child standard to be dominant in this analysis. Whereas clearly the adoptive family and the father's attorneys clearly have a particular custody result that they're each looking for. And really the tribe's interest and the government's interest is in maintaining the sovereignty. And that all of these different interests don't necessarily sync in easy ways with one another, right. Which I think is a really interesting thing about this case. And I think that it puts into tension all of these, no matter what sort of realm you're functioning in, family law in general is some of the most painful law to be involved with.
Can I just add, so I have to remember, as I read these cases, my background, my writing is in the law and policy relating to Native peoples. I have to try to put myself it's impossible, but I have to try to put myself in the shoes of the Supreme Court, because they have all these cases they're going to decide. Many of them are going to start flowing out of the Supreme Court next month. In June, we're going to hear what they have ruled in the Defense Against Marriage Act, the Proposition 8.5 case from California, the Fisher case on affirmative action from University of Texas, and baby Veronica. All these major cases that are going to start rolling out of the Supreme Court in the next few weeks. There's an interesting kind of contrast, if you will, maybe tension, to see if you were among the members of the court. And let me just focus on the federalism issue here and do a contrast and compare of what the court, if the court sees any parallel or tensions in how they're going to rule on the Defense of Marriage Act, DOMA. Now, the institution of marriage is something that historically has been the province of states. States determine what kinds of rights should proceed and whether to even call it marriage. My home state, well, not my home state, where I live now, Vermont, decided many years ago they were the first state to rule on the basis of state constitutional law, not federal constitutional law, but state constitutional law, that the so-called equal benefits clause of the Vermont Constitution required that same-sex couples be accorded the same type of benefits and protections as heterosexual couples. They left it up to the legislature to decide whether or not that bailiwick of rights is called marriage. It says we're not going to get into the issue of whether that's that the Equal Benefits Clause requires that you get to call the institution marriage. We'll let the elected representatives of the people decide that. We just simply say they've got to be equal, whatever you call it. Child welfare, custody, adoption, foster care, similarly has been viewed as the province of the states. So these are two areas in which traditionally we see the states as being the primary actors, primary governmental actors in those areas, with some resistance ever coming if the federal government tries to intrude. So if you're a justice on the Supreme Court, and you're going to be looking at different points of the Constitution, obviously, to see whether or not these laws are supported under different grants of authority. ICWA, for example, Indian Child Welfare Act, if some of them are motivated, some of the justices are motivated to look at whether or not the whole statute or parts of the statute, they don't need to strike down the whole thing. Oftentimes all you're doing is you're saying, well, that provision of the statute is unconstitutional. The rest of it's fine. We call it the severability provision or notion. So you can sever this part, do kind of judicial surgery, and take out the bad piece, and the rest of it can stay. So they're going to point to different sources of the Constitution. But in the back of their minds, the issue really is how do we balance this, this allocation, this distribution of sovereign authority between the feds and the states. Now, in federal Indian law, here's another dynamic. The court has for almost 200 years, for a better part of 200 years, accorded almost carte blanche to the federal government to legislate in Indian affairs. In fact, to this day, the court has not used has not struck down an opinion on the basis of an act of Congress on the basis of the Indian Commerce Clause. They've struck down Indian legislation on other constitutional provisions, Fifth Amendment namely. So they historically have accorded wide berth to the Congress to do pretty much what it wants in Indian affairs. It's known as a plenary power, virtually absolute. And so that's going into the situation. ICWA has a kind of a, if you had to bet money on it, you'd say, well, 200 years of history would suggest there's no way the court's going to strike down that legislation. That would be a momentous step for them to even strike a portion of the law down and saying it was beyond Congress's authority in Indian affairs. Mucking up with marriage or having a differential approach to marriage than some states may take. You know, state like Vermont, New Hampshire, and most recently this week, Rhode Island, has approved and legalized same-sex marriage, but those couples are denied the panoply of benefits that come to heterosexual couples under federal law. So whether or not that tension is tolerable in the country. So I think that there's some broader lessons there in terms of how these will play out, in terms of how the court can look at its body of work and see, do we need to be consistent? Well, not really, because they're pointing to different prongs of the Constitution. But for us average citizens looking at that and saying, well, how do they hold together? What's the consistent thread through that? Any questions that any of you may have? If you've been doing some reading, New York Times has actually done a couple of articles on the Baby Veronica case, and as I said, 60 Minutes, you can look at an episode some months ago now that focused on the Copro Biancos. But any questions or comments that any of you would like to make? Yeah?
Question about the name of the case. Like, commonly it's referred to as Baby Veronica. But is that because the adoptive parents named her that? And so it's not like officially, like it's not official that her name is Veronica?
Right. I think the Browns have continue to call her Veronica. Because this involves a minor, and historically that's how we style cases involving child welfare cases. They don't use the name of minors in these kinds of cases, so they'll say baby girl, baby boy, adoptive girl, adoptive boy. So it's a privacy interest in terms of the parents.
Okay.
Yeah.
Hi, so this is, I guess, with your background and your teaching this, how do you explain the complicated case of political rights that the ICWA is based on with the blood quantum issue, because it does seem to kind of contradict itself that this isn't a racial classification, but it's your political rights are based on blood quantum.
Right.
So if you could explain how you answer to that and how you tease that out and explain to someone who may not have a federal Indian law background.
Yeah, good question. And this is one that it's not clear that members of the court remember their own jurisprudence. And to be fair to them, they decide lots of cases. And one week they're deciding a complicated corporations-related question, and then along comes a federal Indian law case. So I want to try to be fair to them that this is a very, very complicated body of law. But in response to Makakwa's question, back in 1974, the court decided a case called Morton versus Mancari. It really was one of the first, in terms of its posture, it was one of the first affirmative action type of cases to get before the U.S. Supreme Court. And the issue in the Mancari case, the case was a class action lawsuit brought by a woman named Carla Mancari, who was an employee of the Bureau of Indian Affairs. And she had been passed over for a job that had opened up within the BIA. And it was very clear that she was, it's not because she was not qualified, it's because she was an Indian. There was a preference built into federal regulations dating back to the 1930s called Indian Preference Regulations that said, for comparably qualified individuals, if you have a native person and a non-native person competing for the same job or for the same promotion, so it applies to hiring and promotion, with comparable qualifications, the preference must go to the native person. That's the law Ms. Mancari was challenging. Quite evidently, she's challenging it on equal protection grounds. You know, she's like, you can't do that. You can't just blatantly, brazenly say, the Indian gets the job. So she sues on two theories. One was it violated a whole panoply of federal statutes in equal opportunity in employment, Title VII, and a number of other federal statutes that were in the genre of the Equal Opportunity Act from the 60s and 70s. The second argument was a constitutional one. The court rejected both of those arguments. On the statutory claims, the court says, well, normally this would violate all those guarantees, but Congress knew what it was doing when it wrote these laws, because if you read Title VII, it itself contains an exception. It allows for discrimination within tribes, and even allows private corporations, companies, to discriminate in the hiring and promotion of Native peoples if those companies are located in the language of the statute on or near Indian reservations. So if I'm IBM and I've got a plant 2 miles from a reservation and I want to promote, I want to be a good corporate citizen, and I want to hire Native peoples in kind of my own affirmative action program, Title VII gives me the blessing to do that. So the Supreme Court said Congress, far from recognizing this as a conflict, did more of it, kept writing these exceptions, these preferences. So you lose on the statutory argument. Then they got to the equal protection, the constitutional argument. Now, because this is federal, it actually was framed as a due process claim because, well, there's no equal protection language in the Fifth Amendment, but it has been interpreted to include equal protection rights. And the court says you lose there as well, because they said in a passage that has been very criticized, heavily criticized over the years, they said what's going on here is not race-based discrimination at all. The classification runs in favor of a person who is a citizen of a different sovereign. So the court pointed out that said, you know, not everyone gets favored here. You have to be a citizen, an enrolled member of an Indian tribe. So, for example, it wouldn't apply to people like me. I'm a Native guy, but my tribe is not federally recognized. We have no treaties with the federal government. We're not the subject of any formal regulations or judicial decrees, etc. So if the government hired me over you, if you were a non-Native person, that would be race-based classification. I would be favored over you on the basis of my race. But if I'm a citizen of a government that happens to be an Indian tribe, The Supreme Court said that is not a racial classification. It is one of the arrangements by which a government-to-government relationship, the federal obligation to Indian tribes, is being discharged. In other words, the court says the government saw this as a way to advance and entrench tribal sovereignty by allowing the primary federal bureaucracy that is discharging federal obligation towards Native peoples to be populated primarily by Native people. Now notice the preference is only limited to those agencies of the federal government that are uniquely situated and have as their primary responsibility Indian affairs. So for example, the FCC or any other, the FDA, all the alphabet soup of the federal government, there should not be these preferences unless that office has a unique charge of discharging the federal trust obligation to Indian tribes. So now we see a proliferation of other agencies within the federal government. The Indian Health Service, the Department of Justice has an Office of Tribal Justice. The Department of Education has an Office of Indian Education, and so on and so forth. Each of those would be also protected under this regime. Now here's going back to Makukwa, at the heart of your question. The court there did a bit of a sleight of hand, and this is why Mancari has been so criticized. The sleight of hand is this. By shielding this, by creating a kind of safe harbor for federal legislation to do something that in almost any other context would be prohibited by the Constitution because it would be race-based classification. The safe harbor rests on a bit, I don't want to say a fiction, but a bit of disingenuity. Because as you said, if you look at, well then if it protects members of an Indian tribe and that tribe is federally recognized, well then how do you become a member? What's the basis for becoming a member of that political body? And virtually every tribe in the U.S. uses some kind of blood relation. It's either through descent, that you descend from an unquestioned progenitor. My great-great-grandfather was on the Dawes roll, on some sort of roll, and I descend, no matter what my blood quantum is, as long as I can show descent, I'm in. Or you meet a particular blood quantum, 1/4, 1/2, 1/8, 1/16. Now this is a hearkening back, this is an internalization of what was an imposed policy. The federal government was the one that created this blood quantum system. And it was designed in a way to eventually terminate the federal obligation, knowing that through intermarriage, as each generation of Native people intermarried outside, exogamous marriages, marriages outside of the social group, at some point you'd reach a point where the person who's full blood today, their descendants will be half blood, their children will be quarter, and then so on and so forth. So you'll reach a point where if you set the threshold at, let's say, quarter blood, in about 1 or 2 generations, there will be no Indians, no legal Indians. And the federal trust obligation also ends. That's why it was put into place. Well, what has happened now is that many tribes have internalized that system and now impose their own regime of bloodline descendancy or blood quantum requirements. And that is what the Chief Justice Roberts kept hammering away at. I think he wanted to open that up and kind of put a spotlight on there and say, but you got people with just such a tangential claim to Indianness. And why that is such a controversial position to take is that how we reckon one's sense of participation in the life of a culture? Your blood tie to that culture. And some of the justices tackled that as well. They said, well, suppose a tribe, hypothetically, Chief Justice would not let this go. So suppose you had a tribe, hypothetically, that had no blood quantum requirement whatsoever. If you felt Cherokee, as a child, I've actually had people tell me this. They said, I've always felt Indian. I said, how does one always feel Indian? He goes, well, I never got lost in the woods when I was a child. I kid you not, I've had people tell me that in my years here and back home in Louisiana. So I feel Indian. So Chief Justice Roberts says, what if you have that kind of a character coming along? Says he feels Indian. And the rules of membership are so loose that would justify inclusion in the body politic. Now you have someone who has no Indian blood, and the statute just simply defines an Indian child as someone who is an Indian child who is enrolled or eligible to be enrolled in a tribe and is the biological descendant of an enrolled tribal member. So now you have a guy who's not Indian blood-wise, giving birth to someone or participating in the birth of someone who has no blood tie. And I think the Chief Justice's concern was, where does that stop? What kind of can of worms are we opening up? And that betrays a real profound, complicated examination of what does it mean to be Native today. And that is a very, very difficult politics in a variety of settings. What constitutes Indian-ness? What are our markers of indigeneity? Because before there was any allocation of rights and privileges and the right to run casinos and to exercise political power, in other words, now that there's power attached to this, there's now a premium on being clear about who gets to play that game. And as mainstream Americans look at this and they see people like me who look like an average Joe, they might not necessarily see me as a Native person. I'm always a disappointment when I come into a room and they said, Professor so-and-so, Native American Affairs, and I walk in and there's this kind of, because the guy didn't look Indian, you know? And so it's like, well, what if that's what we have in Indian Americas? People who look like me. That will challenge people's ideas not only of what is indigenous, but also, should you have any special rights that I don't get to have? And this is what's driving a lot of this discourse. People observing things that you get to do something that we don't get to do. And so it just is going to intensify, I think.
Well, and it's also, I think, in some of the questions that are coming up in the oral arguments, it's not just why do you get these special rights,
Right.
but why should those rights trump the rights
Exactly.
of other people?
Yeah.
So, for instance,
Innocent bystanders, like the Capobiancos.
like the Capobiancos, or like one of the questions that comes up when the adoptive parent's attorney comes up at the end for her rebuttal time and gets cut off right at that point, is she raises the specter of, so the person in New York City who has the one-night stand, and the guy who she happens to have the one-night stand with happens to be Native. So she gets pregnant. And because he happened to be Native, that all of her rights as an individual, as a woman, her reproductive rights, her decisional rights, have now all of a sudden been trumped by a person who never would have had any sort of rights in any other circumstance.
Yep.
And so that it's not just sort of but it's also an intrusion onto the exercise of other people, which I think, as you had mentioned before, there's sort of the specter of all of these other cases that's hanging out in the background that they've heard, you know, that they've heard, and they've been very, very, at least so far in the oral arguments in a predictive fashion, very skeptical of in the affirmative action arguments. In the Shelby County, there was a oft-quoted line from Justice Scalia where Justice Scalia called the Voting Rights Act a racial entitlement program, which we can talk about that as a different issue. But there's a resistance to any kind of discussion about race and entitlement in any kind of way, and I think that's why the blood quantum issue becomes such a point of tension in this conversation, because it's the invocation that really this is not, clearly it is about sovereignty, but that sovereignty is also has a racial component to it.
Yeah, and I think that's what makes these cases so compelling. I mean, it's a way for us to get take a temperature of where we are as a nation in terms of how we do respect difference and what are the limits of respecting racial and ethnic differences. And when you attach it to the exercise of a political power, which is unique to Native people, the unique status of Indian tribes as governments, where no other minority group in the U.S. can make a claim, a comparable claim, to exercising political authority. And so this is a unique body of law, but it triggers familiar concern. So in this case, for example, Julie's reference to the affirmative action cases may signal that the court may want to look. It hasn't so far, but at some point the court may want to look as when you have situations where the interests of other people, which are invariably going to happen in these adoption cases, are going to keep bumping up against dual commitments to Indian tribes and to their long-standing, to their continuity and cultural integrity and so forth, but also commitments to these other freedoms that individuals enjoy. How do we mediate those? And so, borrowing a page from the affirmative action cases, the court might say, well, this is going on the remediation thing. If what the Congress has put into place is something to remediate a particular history of discrimination, we may have a tolerance for that. It's to fix a very specific problem. And we'll tolerate that kind of classification scheme for that limited purpose, whether it's the schools or particular employment issues or something like that. If they apply that in the adoption context, remember how I opened up? I said that ICWA was written in response to a widespread practice among many states, not all states, but many states, of the outplacement of Native children. Suppose the Supreme Court says, well, you can get away with that so long as that particular state still has that particular problem. In other words, if the outplacement of Indian children is still a problem in Minnesota or Alaska or Arizona or New Mexico, then this scheme, well, it still makes sense. But if it's not a problem anymore, in other words, if ICWA has done what it was set out to do, which is to stem the tide, then we may not need it anymore. I hope they don't go in that direction for two reasons. One, you're going to have a disparity of what ICWA means. I mean, the very purpose of having federal legislation is this interest in uniformity. So you'll have a disuniformity in terms of the quality of rights as this particular statute provides. The second thing is ICWA hasn't solved the problem. 40 years after ICWA, we still have some states that have these high rates of outplacement. In other words, in many states, it's still happening. Native children are removed from families at higher rates than in any other group in that particular state. This is not limited to the United States. Other countries with indigenous populations also can point to a similar history. Australia has a particular name for this phenomenon. They call it the stolen generation, where an entire group of folks have been systematically removed, some of them institutionalized, put in orphanages, others who passed a certain skin test, who could be assimilated more quickly or were placed for adoption. I remember seeing, I was in Australia years ago, and a woman who had been taken from her birth family, her Aboriginal family, had filed a lawsuit against the state of New South Wales for intentional infliction of emotion. I used to teach torts. I don't get to use this phrase too often. Intentional infliction of emotional distress, IIED. But the other one was a form of false imprisonment. She goes, I was wrongfully taken away from my family and denied access. And she showed her papers on the screen. And these are state papers, and where it says the reason for removal, 2 words were in that blank: being Aboriginal. That was enough for the state social workers to remove her. It's like, oh, the reason, the imperative for us to remove you from this home is you're being Aboriginal. And that goes against, we have to do something about that. We have to make you un-Aboriginal. And so this was really the underlying justification for that. So they're involved in a similar discourse. They look to the U.S. and say, should we have an Indian Child Welfare Act type of thing? Well, they couldn't really, because Australia doesn't yet recognize their Aboriginal population as possessing rights of sovereignty. In other words, there is no governmental structure that could work as a partner with the federal and state governments the way that we have here in the U.S. So even though there's a lot of bad news in this area, I always try to remind my students there's some good news here, that we are still working in a government-to-government framework. Sometimes the deck is still stacked very much against tribes, but the fact that we can even have that kind of conversation when I compare it to what's happening in other countries shows that we have made some pretty tremendous progress in this country, and I never want to lose sight of that. Any other? We've got 5 minutes left, so Xander.
So the Holyfield case, which you had mentioned, is a case that Justice Scalia has noted as being I think he said it's something like one of the most troubling of his career.
Yep.
And in that case, he voted with perhaps the side of the court that he normally does not align himself with. And so I'm wondering, I know it's speculation, what your thoughts are on how he may come down this time around. He has been such a proponent normally of sovereign rights, but then how does this fit with perhaps some of his other thoughts on some of the other issues that are going on here?
Yeah, good question. I mean, he said enough here in terms of keeping the focus on the statute. He said, but that's what the statute says. When Justice Ginsburg, when they were talking about the definition of an Indian child, Justice Ginsburg brought us back to the definition. He goes, yes, that's what the statute says. I mean, he's a textualist. It's like, start with the statute. I suspect, even though it'll be the basis for his next interview with Charlie Rose, which is the show in which he said, he was asked, could you give us an example of a case that really challenged your sense of, what were the demands of justice versus what were the demands of the law? And he kind of hunted it around for a while, but then he came up with the Holyfield case. After all these years, that's the case that stood out for him. And he said, that case really troubled me because he says, if I could have imposed my will, make my judgment on that case, I think the parents should have been able to do what they wanted, meaning the Choctaw parents could have left the reservation and put up their kids for adoption like anybody else in the U.S. can do. He didn't see that it was right that they were everyone was forced to go back to but he says, that's not my job. My job is to apply the law, and Congress made its intent very clear. So I bank on him following that same kind of impulse and applying ICWA. I don't know.
I will, no, he's without question. I mean, from the oral arguments, he's with Congress on this one. But what I find really interesting about that is comparatively to the Shelby County case, because he keeps sort of circling back in this case to Congress made it clear what it intended, and they made those intentions clear in the statute. And yet his argument in Shelby County was that no one actually in Congress voted against renewing Section 5 of the Voting Rights Act. So therefore, it showed that Congress somehow shouldn't be listened to in that setting, because clearly Congress is being overly influenced by politics, and their decision-making can't be trusted in that situation. So I find the listen to Congress sort of approach, I think he's very much on board in this particular case.
It's convenient, perhaps, for him in this instance.
Well, Xander, one other thing that reminds me of, that your question reminds me of, the court in Holyfield only had Justice O'Connor as the only woman in the Supreme Court. Now there are 3 women on the U.S. Supreme Court. I've had some students ask me, will that make a difference in the way that the court rules in its decision? Based on their questions, I think it has less to do with gender than their particular philosophy in terms of how to approach these particular issues. I think Sotomayor, who was very, very active in this oral argument. In fact, there are at least 2 passages where her fellow justices.
Has to be shushed.
Yeah, she was shushed. She was shushed at least a couple of times. Like, let him finish, you know. And other times where she's actually trying to help the lawyers, and justices often will do that if they see that someone is being beaten up by the other justices and stuff like that. Well, isn't your answer that Section 1911? Yes, that's my answer. And then you shut up, you know, and let it go.
Justice Ginsburg, why are you fighting Justice Breyer
Yes,
right now?
yeah.
Yeah, I wanted to jump actually into the Voting Rights Act case just very briefly, because that, I think, follows the exact pattern of what you were talking about in terms of remediation and the decision about whether the problem has actually been solved or not, because that was the essence of the oral arguments and the essence of the fight in the Voting Rights Act case, which is the Voting Rights Act was a core piece of civil rights legislation passed in 1965, deliberately designed to address disenfranchisement based on race, and it has been enormously successful over the years, and one of the core features of it is this Section 5, which targets particular covered counties or particularly covered jurisdictions, that if you have a past history of voting discrimination, anytime you need to want to pass a new voting law, you need to be that law needs to be pre-cleared. And so the challenge that's being brought right now is Congress keeps renewing that, but the formula that is used for whether or not you're a covered jurisdiction dates back to information from a very long time ago, and the argument is, haven't things gotten so much better now that there's no need for this anymore, which is sort of has the problem, has the statute outlived its usefulness? Is the problem still existent enough to warrant the infringement? And in the Voting Rights Act case, the infringement on states' rights to determine their own voting laws. And that was the essence of these oral arguments is, yes, things have gotten a lot better, but are they better enough? What are the measurements that you're using to determine whether it's better? You know, the original criteria were based on voter registration and turnout. Well, voter registration and turnout isn't really the issue right now anymore. It's things like, has there been a last-minute move of a polling place to make it more inconvenient, or to locate that polling place in an area that is historically discriminatory so that it will be sort of intimidating and deter people from the polls. So they call it the second generation of voter discrimination laws. And does Congress need to go back and review its formulas? Has the law become unconstitutional over this period of time? And there was a big conversation in the oral arguments about, well, is part of Section 5's effectiveness is in its deterrent value, that because states know that they will have to go through a pre-clearance process, does that actually effectively deter? And if you remove that, what are you opening the door to? Which I think has a similar sort of parallel here too. But I think what's interesting about all of these cases, though, is the way some of these things are echoing in the Baby Veronica case, but with this new layer of the sovereignty issue, which changes the conversation in really significant ways.
I think we'll leave it there and invite you to join us down here for any questions or maybe outside. There will be another panel starting at, I'll let Xander tell you what the next panel will be.
So at about 4:45, we're going to have a panel of 3 women lawyers who talk about their experiences going to law school and the different things that they have done in their legal careers. And so anyone who's considering law school or who has perhaps some questions about about that. I recommend you stay, and that's going to run until 5:45. I realize it's late and it's a Friday, and I would just like to take this moment again to thank you for coming. We really do appreciate it. We know we're competing with beautiful weather outside, and so thank you very much. And for your friends who couldn't make it, this is being recorded, and both of our presenters have agreed that this can be released on the Dartmouth YouTube channel, so you can encourage your friends to watch it later. Yes. Thank you.
Thank you very much. Nice job.